If there's one thing that NSA values, it's secrecy. It has been allowed to operate in ways that aren't always consistent with public's understanding of the laws, the Constitution, or even other parts of the executive branch's interpretation of the laws.
Opposition to the government's sweeping surveillance.
These programs are within the law.
In the abstract, you can complain about Big Brother.
Hi, I'm Zach Weissmuller for Reason TV. I'm here at the Electronic Frontier Foundation's San Francisco headquarters. I'm talking with staff attorney Mark Rumold. He's done work on a lawsuit challenging the right of the U.S. Department of Justice to keep its surveillance activities shrouded in secrecy. Mark, thank you very much for talking to us.
Thanks.
The purpose of EFF's lawsuit against the Department of Justice is to get the details of an unfavorable ruling that a FISA court gave to the Department of Justice regarding surveillance.
Right.
When did EFF first file this lawsuit, and what are the latest developments in the case?
In the run-up to the reenactment of the FISA Amendments Act in 2012, Senator Wyden pushed the executive branch very hard to declassify 3 statements. One of them was that the FISC had held that some of the executive branch's surveillance under the FISA Amendments Act was unconstitutional. Another was that the FISC had held that the surveillance they had conducted had violated the spirit of the law. And then, so actually there were only 2, and then the executive made him include that the FISC had that the executive branch had corrected those problems.
Just to clarify for our viewers, the FISC is the FISA court.
It's the Foreign Intelligence Surveillance Court. It's a court established by statute that hears government applications to conduct electronic surveillance in national security cases. So with those public statements made, that was the first time that the public had known that the government was conducting surveillance that had been determined to be unconstitutional. We filed a Freedom of Information Act request with the executive branch for that opinion. The executive branch came back, said it's classified, we can't disclose it. So we sued because it's our position, and it's actually the executive branch's position too, that they can't classify information just to conceal violations of law.
And it's interesting because you are saying you wouldn't even have known that it was being concealed if not for Senator Wyden, saying something about it.
And Senator Wyden couldn't even say anything about it until it was cleared by the executive branch to say it.
Right.
So Senator Wyden, I imagine, pushed very hard to have that information disclosed. And thankfully it was. So we filed suit in the district court in Washington, D.C., and the government came back with a pretty strange argument. In addition to saying it was classified, their argument was their hands were tied because of the judiciary. And it essentially was the executive branch trying to point the finger at another branch of government, saying, oh, we'd love to disclose this unconstitutional surveillance, but we can't because of the judiciary.
The FISC ended up ruling in your favor, which I believe was the first time ever ruling in favor of a non-government entity.
Right. That we know about.
That we know about, because there's all these layers. That ruling came out after the revelations that Edward Snowden leaked came out. It's hard to imagine that that's coincidental timing.
I'm not surprised by the FISC's decision because the government's argument was crazy. And I think the FISC was right to reject it, and to reject it quickly. At the same time, I think judges on the court don't exist in a vacuum. I think they were hearing a lot of the criticism they were receiving in the press, and seeing how the order was being construed in the public, and I think that may have contributed to it, but I certainly think, or at least I hope, they would have held in our favor regardless.
So at this point, we know that the FISC ruled against the Department of Justice regarding something to do with Section 702.
Right.
That's about all we know, right?
Well, so we know it had to do with the minimization procedures.
Okay.
So basically, the procedures the government uses to ensure that U.S. person information isn't swept up in the surveillance that they're doing. The FISC held that those procedures were unconstitutional, that they violated the Fourth Amendment.
Do these give us any clues as to what might be going on, what it is that the Department of Justice was doing that the FISA court actually ruled against them and said this is in violation of the Constitution?
Right. I don't want to speculate because there are a number of possibilities about what they could have been doing that was unconstitutional. But I think at the very least, we know that it involved, if not citizens, it involved, legal residents within the United States, and it involved their communications in some way.
What has the Department of Justice's response been so far? Are those papers forthcoming?
No response so far. We have a status report in district court in Washington, D.C. due July 1st, so hopefully we'll find out more then. But it's our position, and based on their previous filings, that they will have to release at least part of the opinion now.
Have the leaks given you momentum, or how have they affected all of this?
It's raised public awareness about it. It's raised congressional awareness about it. A lot of members of Congress, I don't think, were briefed on how these programs were being used. The disclosures also help our cases, right? So in the 215 FOIA case, they had claimed that they couldn't disclose anything because it was all classified top secret. We were just asking for legal interpretation. We were looking for like a legal memo that says, this is how we interpret our authority, and this is how broad it is or how narrow it is. And they said they couldn't release it. It was top secret.
The fact that you have to navigate all these layers of secrecy just to get the most basic bit of information that you wouldn't have even known that you should start navigating unless one senator hadn't mentioned it in the first place.
Right.
What are kind of the first reforms that you think we need to enact to kind of alleviate that problem?
What EFF is pushing for is a full public, that's the critical element here, is a full public debate about these surveillance programs, about the scope of the government's authority. The government has been going about the process in the wrong way, right? They've been doing things behind closed doors, and then when they get caught, trying to brief members of Congress, trying to brief the judiciary. But this time around, we need to start with the full public debate, then figure out what reforms are appropriate, figure out what surveillance the American public is comfortable with.
For those people who, care about privacy and care about government surveillance and want to do something about it and want to help EFF push back against it, what would your advice be?
We have a petition that we would welcome more signatures on. It's stopwatching.us. We encourage people to call, to email, to do whatever, just to be angry about this type of invasive surveillance.
Mark Rumold, thank you very much for talking to us.
Thank you.